Welcome again to YouTube Tuesdays here at Melling Law. Today we're going to do a little legislative update now that our Utah legislative session is over. There were a lot of changes this year, and really, you could spend hours talking about the different changes. We're not going to do that because we don't practice all kinds of law. We focus on estate planning and business planning. So we're going to cover some of those changes that affect transfer of property and estate planning here in Utah. Last year we had a huge change with the Power of Attorney Act. We gutted any existing provisions we had about powers of attorney, and we replaced it with a uniform act, somewhat tailored to Utah's needs, and it created a standard form. It's really made my job a lot easier and the bank's jobs a lot easier. There were just a few glitches, and we were able to take care of that in some custom language in the special instruction sections of those documents. So that was a big change that we had last year. Nothing like that this year. One of the changes we were watching, it ended up not making it past committee, but because it could come up later, we'll bring it up, is the Transfer on Death Deeds Act. There are other states that have passed these kinds of acts, and what they do is it allows people, without necessarily putting their property into a trust, to be able to bypass probate by creating a pay-on-death beneficiary if you're a transfer-on-death beneficiary of their real estate. And they just, that's in the form of a deed. They record it at the county recorder, and then the recorder will transfer the deed to that beneficiary upon the death of the person executing the deed. These work out in theory, and it does save families some money as far as estate planning goes, in some cases, and others it really doesn't. But because of the prevalency of fraud with these kinds of deeds in other states, the elder law section of the bar actually formally opposed the bill. We're going to see how that works out in future years. Maybe they'll come back, but the elder law section of the bar really went into depth in the email to its members about some of their concerns, such as the high cost of reversing the fraudulent deeds. We're talking about tens of thousands of dollars in litigation fees. So most middle-class families don't want to deal with that. So they formally opposed the bill. We shouldn't be seeing that again because of that opposition, but it could be that it comes back. So we'll watch for that. One thing that did pass was the Fiduciary Access to Digital Assets Act. And what that allows is fiduciaries, so that's a personal representative of a will, a trustee of a trust, an agent on a power of attorney, anyone that has a fiduciary responsibility over a person can access their digital assets and manage them if it's provided for in the instrument, or there are some default provisions if it's not explicitly granted. In theory, what this is supposed to do is help those fiduciaries manage the digital assets of the person, and we have so many digital assets now. There are some people who have digital currency, digital access to their bank accounts. They have intellectual property stored on their servers, whether it's through a provider, like a cloud provider like Google, or whether it's a private server. Any of these kinds of digital assets, in theory, should be accessed by the fiduciary, or potentially could be accessed by the fiduciary. In practicality, though, many of these arrangements are dealt with directly through the service provider. If you have a Gmail account, for instance, that's handled directly through your terms of service with Google. Facebook, same way. A lot of cloud storage platforms work the same way. So unless you're Hillary Clinton and you have a private server in your house, odds are your digital assets are all handled by contract through your service providers. Now we'll see over the next few years whether or not this state law is going to supersede those contracts, or to what extent it will. So keep an eye out for that, but that was one of the major changes as far as estate planning goes this year. There were two others that I wanted to bring up briefly. One, just in passing, there were some revisions to some of our structuring with boards of directors and corporations. Those really aren't going to have a whole lot of effect for middle class families, so we won't go into those. The other one that could have some effect depending on the estate plan is a Power of Appointment Act that was passed. Now, powers of appointment are, it's an estate planning tool. It's not used very often, mostly because we didn't really have many provisions governing it, so there wasn't a whole lot of black letter law to go off of. But a power of appointment is a system by which you appoint somebody to determine what happens to property. So, like a traditional trust would say something like, I want my assets to be liquidated and sold, or however I want my assets handled, and then distributed, say, to my kids equally. Instead of doing that, in theory, what I could say is, maybe I have one problem child. And so I want as many shares created as I have children, and I want those all distributed to my children except for my one problem child. And I want to give a power of appointment over that share to maybe my brother or some kind of trusted friend or family member, and give them a power of appointment to decide what happens to that property. And they, at their sole and absolute discretion, would be able to maybe leave that to my problem child or to somebody else. The reason why this differs from trust language is sometimes in a trust we'll say, I've got this child, I don't want their share to go to them unless they fill the following criteria. The problem with that is sometimes it ties the trustee's hands. It's too specific. So a power of appointment gives more authority or discretion to a third party. There are a lot of upsides and downsides with that. So this act simply clarified some of the rules under which that kind of a system works. We'll see how it ends up working in practice. Once again, I don't imagine this being used with too many middle-class families, but there might be some special situations where we start to use these now because we have more of a framework from the state legislature. Thanks for watching. This one was a little long, but just to kind of recap, we no major updates that are really going to change the way estate plans are done this year in Utah. We did have a Digital Assets Act passed that will allow, in theory, fiduciaries to access digital assets of somebody that they're representing. There was also an act about corporations, really not important for most middle-class families, and then about powers of appointment that probably will be used more than it is now. Still not a whole lot, just because it's not going to affect most middle-class families. Thanks for watching. If you have any questions, you can always reach us at 435-572-0807 or at mellinglaw.com.